I would like to start our conversation with a short introduction of my distinguished co-speakers, and I will start from Kostyantin Degtярьов, who is the professor in human rights of the School of Law and Social Justice. He joined the University of Liverpool in 2015, having previously worked in the University of Surrey, University of College of Dublin, and Gomal State University. Konstantin is an author of numerous books and articles regarding the human rights law, and also is the co-founder and co-editor-in-chief of the European Convention on Human Rights Law Review. Thank you, Konstantin, for having time to have a talk with us. And also Nікколо Ріді, who is a senior lecturer, associate professor in public international law at King's College London, where he is also an associate director of the Center of International Governance and Dispute Resolutions, and also an academic fellow of the Honorable Society of the Middle Temple. And my name is Rasіма Бабанли. I'm first Deputy Chief of Staff of the Supreme Court. We also deal with the implementation of the case law of the European Court of Human Rights into Ukrainian national legal system. We work a lot on these issues, and that's why your article attracted a very big attention for the members of Ukrainian judiciary, for the members of the bar associations. It discussed quite much in the social medias. So therefore, it seems to me that it was a very nice idea of our JustTalk platform to provide such a conversation and to discuss in person what were your ideas and how you think about implementing maybe later researches and how to implement the conclusions which you made according to this research. Now, if I may, maybe I can give the floor to you for some introductory remarks, and then we will discuss the particular topic of our today's conversation. Please, Konstantin, the floor is yours for introductory remarks.
Okay, thanks very much, and thanks for kindly introducing us. It's very important for us too to actually tell the audience a little bit more about the paper, because the paper is already very long and very comprehensive. But there was plenty of information that didn't end up in the paper. So I will just give a very brief overview of the paper and then pass to Nico, who can elaborate on specific parts or something like that. So the idea of the paper was to really see and empirically test how the European Court of Human Rights engages with scholarship. Not only legal scholarship, but scholarship is in very, very broad meaning of this term. So basically how the court engages with articles, books, newspapers, journals, etc., how whether there is any impact of these sources on the decision making of the European Court of Human Rights. And I, having dealt with the European Court for many, many years, I had a feeling that the court doesn't do it very often, and it doesn't do it very systematically. While the latter assumption was somewhat confirmed by our empirical study, the former assumption was somewhat problematic in a sense. So the court, especially the dissenting judges in their dissent and their separate opinions, they're using citations, quotes to scholarship fairly often. And this is an important finding, especially in the grand chamber cases. Just to give you a little overview of the methodology, we took all the judgments of the European Court of Human Rights, the grand chamber judgments of the European Court of Human Rights, starting from 1998 to, I think, 2021, and read them all and tried to identify any single citation that was used in all of these judgments throughout the years. And we found them and tried to analyze the results that we got. And this paper actually is at the beginning, so to speak, of the analysis of how the court is using scholarship in its case law. Nika.
Thank you very much. And yes, I mean, I think you raise a few important points, which I would like to double down. First of all, I mean, it's been an interesting thing because it started out as a collaboration because Konstantin wanted to do something. And so I joined in as an empirical legal scholar. Konstantin was also very instrumental in pushing me to actually do it because it was slowing down the process quite a bit because I tend to be on the lazy side in some of in some of these things, but in the end, the collaboration was very efficient. In this regard, I think for me there were a number of things which were very interesting. I'm mostly somebody who looks at international courts and tribunals in general. I'm mostly a public international lawyer in the traditional sense of the word. So I look at international courts as international courts. Not, very much like, in many ways, the way that lots of scholars of the European Convention of Human Rights do so. And for me, there were some assumptions which I think were true in international law in general, such as what we know from the doctrine of sources of international law about the role of doctrine, of the role of scholarship in general. And this was an interesting case study because, of course, the European Court of Human Rights is, of course, an international court, but sometimes they have to be told that they are one, right? Sometimes they don't behave as if they were an international court, and they have their own rules about doing certain things. So these raise a number of different questions concerning, first of all, how judges of the court engage with scholarship, but also how we define scholarship for the purposes of the European Court of Human Rights. And this, of course, led us to adopt a fairly inclusive, I suppose, definition of scholarship, because, of course, it was not a given that the same definition that applied to Article 38(1)(d) of the Statute of the International Court of Justice, for example, could be applicable lock, stock, and barrel to this particular scenario. And the second point, and I suppose comes from what Konstantin said about if you look at the jurisprudence of the court and if you take a bit of an anecdotal view of what it is that they are doing, chances are you will immediately realize that there is something about scholarship that is distinctive and particular, and they are using it. However, you will be forgiven for thinking that the practice is all over the place. It is not really clear. There is no real way that has been systematized and codified of engaging with scholarship, which I will say for my specific purposes in working with this article was a major problem because, of course, one of the things that we always think about when we think about citations are, citation styles. And if there is no consistent citation style, that already creates a major problem because finding citations requires an enormous effort. So even from the perspective of, pure transparency in elucidating how you come to a particular decision, this becomes rather challenging because, of course, in order to determine how a particular source has been used, there is no machine learning that can help you. There is nothing really that can, now with language models, it's a little bit easier and we could do that. But still, it was quite challenging to actually identify all of the citations. And just as a final point, which I will make, I think Konstantin is absolutely right. There was a lot of material that at the end of the day, it was impossible to just put into the article, because the article was already extraordinarily lengthy, even for the standards of the International Comparative Law Quarterly. But still, we are aware that this essentially only barely scratches the surface, right? Because we have focused on the Grand Chamber. And of course, this is without prejudice to any sort of discussion that could be had about every other instance of judgment by the court, plus all of the decisions on admissibility and so on by chamber and committee composition, which might still, engage with this kind of sources. So the data is out there. Eventually, we will get to it. But the point is, again, this is just one way to show this degree of complexity and this degree of difficulty on a fairly sizable, but still relatively limited sample size.
Thank you for explaining the initial idea of having conducting such a research. But I would like to clarify even more. Was your initial idea to understand what is the state of play in the use of the scholarship, or having made such a first step, you wanted to encourage judges, maybe of the European Court of Human Rights, all judges all over the Europe, to encourage them to use the doctrine more and to provide the citations? Did you have such secondary aim, or maybe the primary aim, not to understand what the state of play is, but to encourage to use the doctrine more and more?
Nika, maybe you can kick off with this question, especially from your side, and then I'll add on.
Thank you, Konstantin. I think it's a very important question, right? We wanted to have some sort of, our first idea in this article was to essentially carry out the first analysis of this phenomenon. So we did not take the view that we were in such a position to give directions to the court and to the judges, who may, of course, have their own agenda and their own needs when it comes to engaging with scholarship. And of course, we are not as well placed as they are to determine how they are going to use a particular source. And that is the starting point for us. That said, the interesting part of it for us was that, again, there wasn't, there didn't seem to be a standardized practice. There didn't seem to be any practice directions. And this is something that, for example, is not necessarily consistent across the board when you take the whole universe of international adjudication into account. For example, in the International Court of Justice, of course, nobody will say that, but there is a long-standing tradition of never citing any scholar in the majority opinion, essentially because you don't want to engender any sort of jealousies, and even in the case of minority opinions, by and large, it is going to be dead authors that will be cited rather than live ones, so to speak, just in order to avoid any sense of, I suppose, lack of impartiality or alignment, ideological or otherwise, with a particular idea. So there are some ideas, there are some things which we know exist in terms of practices, but it was very, very difficult to find anything in this regard with the court in mind, which also, I suppose, was something that led us to make some recommendations of sort in the article itself, although they were very timid in a way, because of course we are aware that there might be other needs that absolutely would trump the matter at issue, such as, for example, suggesting a slightly more transparent engagement with sources, because of course sometimes it is not entirely clear what a particular source has been used for and why a particular source has been selected. This, of course, extends not just to the minority, but also to the majority, because in many cases we can take essentially the positions of minority judges as indicative that a particular source has been discussed and debated. So this is a proxy in terms of demonstrating that this has happened, so as to identify, for example, which scholarship has been debated, and if it has been debated, why has it not been cited by the majority? So this is the kind of question that we would like to perhaps also direct to the judges of the court in order to determine whether or not there can be a more transparent engagement that shows perhaps a degree of engagement between the court and academia at large.
Thanks, Nika. Yes, that's extremely helpful. And just to go a little bit back to Rasim, your question, basically a good piece, and we are hoping that our piece of research is good. But a good piece of research should have a descriptive part, an analytical part, and sometimes normative part. And as Nika rightly said, we conscientiously decided not to go into the normative part. We didn't provide a clear message as to generally whether citing scholarship is a good or bad. Both of us, we have our opinion about that. And I think personally, and this didn't go into the paper, that's why podcast is good to provide added value to this thing. My personal thing is that engagement with scholarship can be very valuable for courts. It can make the discussion more looking from different angles, so to speak. I like when the courts demonstrate their knowledge of academic scholarship surrounded this particular court, or even generally. And there are quite a few, especially apex courts like Supreme Court in different jurisdictions, which do that. And for example, in Germany, for example, the apex courts are known for using doctrine quite often. Now, but as I said, we didn't do that in that particular paper. What we did a descriptive part, and we for descriptive part, it's important to do something which has never been done, right? And we did quite research. We found only one book in French which looked specifically at the citation, which was published by the European, I think it was Council of Europe publication, and without much empirical, it was based on anecdotal, references, anecdotal cases of references to various sources. So we decided we need to do it more systematically, and we asked 4 colleagues, 4 research assistants, to pick manually every single citation from all those hundreds and thousands of pages of legal judgments that we had to look through. And it was not a single easy task, because as Nika rightly said, there is no very clear strategy of the court of how they cite. Sometimes there are examples of citing only the journal and the paper without even mentioning the name of the author. So therefore, every judgment needed to be read in its entirety, and it took years to do. So that was the hardest part. Well, hardest, but more labor-intensive part of the project. And then the next part was analytical. As we said, we didn't ask questions of whether it's good or bad. We didn't ask normative questions, but we did ask questions why. Why the judges would use a particular source? What's the idea behind it? How we can justify using these sources? What are the differences between majority judgments in which the majority agree, which became the final judgment of the court, and dissenting opinions and separate opinions? One of the core, and it is quite obvious, and you don't need to do massive research, but the obvious and very important starting point was that the separate opinions, judges in dissent, use scholarship in many times more often than the judgments of majority. And that also tells you something about how the court actually operates and how the court engages with academic scholarship. And I think like these two parts, and there is a lot to do both in relation to the descriptive part. You can go, as Nico said, into the chambers, into the more specific types of scholarship, narrowing down the research angle, etc. But even more, you can go into analytical parts, into looking into why particular sources used more often, what are the languages of the sources, how the sources are selected, who select the sources, is it a reflection to what the parties submit or not? So like this, these are two parts which are reflected in the paper as it is, and there is like a huge area of follow-up research that can be done here. I don't know if Nico, you want to add anything to that, but yeah, I think I'm done.
No, I think it is entirely accurate. No additional comments from me on this.
Thanks for that. You already in your answers explained the methodology, and you pointed out one of the main conclusions between the usage of citations in majority and minority decisions. And you make a point that when minority judges lose arguments in court, they try to persuade the widest possible audience. How do you think, is there any practical impact as a part of the audience to whom it may be addressed? I can tell my own opinion that for me, the dissentive opinions and separate opinions, they try me to understand the legal problem better. And sometimes when judges are more cautious in their judgment, they can be not so cautious in their dissenting opinions, and therefore it tries to to see what is going on without different diplomatic algorithm which are used to solve the problem which raised in particular case. So what is your opinion about that?
That's an excellent question, Nico. If you don't mind, I will start this one. I think that this idea of audiences, albeit it is not a new idea, I don't think that it was very often applied to the European Court of Human Rights, and especially in relation to separate opinions in the ECHR. And I agree with you that in some cases, the aim is exactly, Rassim, like you said. Basically, the judges want to clarify, want to elaborate, want to demonstrate like the complexity of the issue. But here we mostly talk about concurring opinions. Not exclusively, but concurring opinion is specifically for that, to give a broader sort of understanding of the matter at issue. When we talk about dissenting opinions, there is obviously an element of the confrontation with the majority. So the dissenters lost. So they had an idea and they wanted to persuade the majority, but the majority didn't follow their claim. And here, I think it is important to look why judges write these long dissenting opinions, especially long dissenting opinions. Because in effect, they already lost, right? The thing is done. Like the court decided the way it decided, and the dissenting opinion has no legal value, in very inverted commas, no legal value following Article 46 of the Convention. It's not law. So why bother, right? And in that, answering that question, I think that dissenting judges especially want to persuade. So like their aim is to persuade as broader audiences as possible that their position that the majority failed to adopt is the right one. And why they do that? If there is a growing number of audiences, like national judges, like applicants, etc., that keep bringing cases to the court, keep arguing this particular point that was actually in the minority in that particular case, there is a chance that this point will become the law and the court will reverse its official position once adopted by the majority of the court. And especially, I think the judges want to persuade the audiences in the respondent state. That would explain why some judges would use so much references to scholarship in the native language of that state. So in the cases against Italy, they would use Italian sources, against, I don't know, Germany, German sources, etc. So that would, yes, Mika probably will tell us in a second that this is not an 100% trend here too, because sometimes judges use German sources in cases against Hungary, but you can think about other explanations in that case. So basically, I think that audiences is a very interesting, albeit where I appreciate point that is open to different approaches. So like it's very, very difficult to conclusively say that this particular judge wrote this dissenting opinion with this audience in mind, and therefore they so like this nice and very linear logic doesn't always work. But sometimes judges write this dissenting opinion even conscientiously, not realizing that this is what they exactly doing, while they are doing that nevertheless. Nika, the floor is yours.
Thank you very much, Konstantin. I agree entirely. So I recall that the first time I actually thought about the notion of audience was after a discussion with Andrea Bianchi, who is a professor at the Guardaci Institute in Geneva, and he was for some time technically my boss when I was working there as a research associate. And he had a number of points made about audiences in international adjudication. And his core, I suppose, his focus at the time where he was discussing this particular issue was the judgment of the International Court of Justice in the jurisdictional immunities of the state between Germany and Italy. And that was a fairly controversial case where essentially the key takeaway that was that rules of immunity could, in principle, trump rules that had a nature of that had a peremptory character. Therefore, essentially, the fact that a particular norm was jus cogens did not lift immunity. And of course, there was a question, right? I mean, of when the court is making points of this sort, who are they trying to persuade? How are they going to make this argument? How are they going to do so? And of course, this was true, equally true, I would say, for the majority and also for the minority. Now, in the case of the European Court of Human Rights, in my view, there is also another layer, which I find extraordinarily interesting. When you're thinking about how the court will behave, I mean, its behavior, of course, I mean, they want to be consistent across the board as much as possible in relation to all respondents, but different respondents will attract different judgments. And that, of course, is absolutely true. We know that essentially since when we were made aware of the margin of appreciation doctrine. And this also applies in a variety of other circumstances. For example, there is an article by Eric Voeten and Jonathan Lupo, which proves more or less conclusively that if you look at the selection of precedents, of previous decisions that the court will cite in a particular case against a certain respondent, normally they will be selected among the cases against this particular respondent. And there is a very positive correlation, which of course can be explained by reference to the fact that if I have to tell you what the law applying to you, considering also your margin of appreciation will be, this is how I'm going to do so. I'm going to use the "I told you so" argument. In relation to scholarship, in my view, the situation is a bit different, because still, yes, you can see scholarship cited, which generally comes from the specific area and so on. But there are interesting points, such as, for example, the fact that, and this again goes back to another article by Larry Helfer and Eric Verton, who have written about the so-called walking back dissents, right? So when there is a dissent by a judge of the court, which essentially alleges that the court, the Grand Chamber in particular, has gone back, essentially has become more conservative in its understanding of a particular question. And I think this is particularly interesting because, of course, a dissent and a use of scholarship as an argument, essentially, in a dissent of this sort is particularly powerful. Essentially, you show by referring to the best, to the state of the art, essentially, that we now know that this is the European consensus, that this is the way we interpret the European Convention of Human Rights, and the court essentially has gotten it wrong. Now, this is just one theory, but it is a theory that, in my view, works very well because if you look at how this is done, historically, it is quite possible that scholarship will be leveraged essentially to say, well, this is a good understanding, but the fact remains that we had already agreed and everybody had understood that the court would have behaved in a different manner. And scholarship generally is a good litmus test to determine that this is actually the case.
Thanks for that. A couple of times in today's conversation and a couple of times in the article, you make a correlation between the activities of the European Court of Human Rights in citation and the International Court of Justice. And you mention that there is an Article 38 of the Statute of the International Court of Justice, which lists the teaching of the most highly qualified publicist as a source which may be applied as subsidiary means for the determination of rules of law. How do you think maybe the reason in a high value of customary law in international law and the publications are basically the only source which may prove the existence of a particular rule in customary law? Or maybe the reason is to encourage this court to use the doctrine and to make it as much as possible.
Thank you. I'll take this one because I feel like it's in my area of expertise in some way. First of all, I have to say I have to plug a friend's book on this very topic, which is the application of teachings by the International Court of Justice, which is a fantastic book written by my friend Sondre Torp Helmersen. And I think it is essentially the final word on the topic because it examines the practice of the International Court of Justice throughout its entire history. And I think it is very important to acknowledge that as an important element in this regard. Now, I think you raise a couple of important points. The first point is, the idea that teachings are a source on the basis of Article 38 is a bit of a misnomer because they are not technically a source, but rather they are a subsidiary means, which essentially means that they are a material source to identify actual rules of international law which may be contained elsewhere, which may have been created through either treaty, custom, or general principles. Obviously, the distinction is very complicated. There is an argument to be made that yes, scholarship can amount to a source so long as the relevant community acknowledges it as a source, and in many ways this has been the case historically. And the second thing that I think is important to consider is that all of these provisions concerning in the Statute of the International Court of Justice concerning these particular types of sources, in particular judicial decisions and scholarship, are I suppose, the product of a very strange political and historical compromise between the people who were working in the advisory committee of jurists, the members of the advisory committee of jurists who had been tasked in the 1920s to draft the statute of the then Permanent Court of International Justice. So you have to think about it in a very different situation historically, in a very different historical context, where effectively much of the knowledge about what international law could have been and what was could only be found essentially in leading textbooks, because very simply we didn't have too many judicial decisions, law reporting was not exactly great, repository of customary international law were more or less nowhere to be found, so scholarship very much provided a very strong foundation. And this is also part of the fact that if you compare this particular approach with I suppose the German approach to international law, or the very least the continental European approach, was still very much informed by Buchrecht, and therefore very much academic as a discipline. And we were still thinking, well, maybe Grotius will know about this particular rule, so let's check him out. But this was very much a contingency in a way, because we were thinking about, okay, how can we determine that a particular rule enjoys enough support to become accepted as a rule of customary international law, or a general principle, or whatnot. Now, I would say that this is no longer necessarily the only way the International Court of Justice uses scholarship. So you are absolutely correct. Sometimes the ICJ would use scholarship for reasons of perhaps also progressively develop international law. And this is the case, for example, if you look at many of the dissenting opinions of those who had been traditionally the most progressive judges. For example, Judge Cansado Trindade has been known for relying on enormous amounts of scholarships in very lengthy dissenting opinions, essentially because of this very purpose, because he wanted to advance new progressive novel understanding of specific rules. So I would, to conclude this point in relation to your question, I think there is something very, very, very clear about the ICJ statute attempting to govern, attempting to regulate the matter of the use of scholarship. And I think it is particularly important where they say that they can be used, but they can be used as subsidiary means, not as primary rules governing conduct of states. But beyond that, of course, the court will be more or less sovereign in deciding whether or not they can rely on scholarship otherwise. And in reality, there is really no rule that can prevent the International Court of Justice from citing a piece of scholarship and saying, well, we believe this is the law.
I see that Konstantin completely agrees with the answer. So we may proceed to the following question. So we've already discussed the citation which is made by minority, and what about the majority? One of the points which you make in the article, you say that the citation are made in the judgment when the court feels that he has a lack of competence in some particular question, and also in the cases to provide the interpretation of some national legislation. Can you please explain in broader sense what was the conclusion in these regards?
So basically, I think that we identified three broader areas in which the European Court of Human Rights, the majority of the CHR, uses citations. And first, it was to explain the facts of the case, right? What happened on the ground? Like basically, it very often, it doesn't even have anything to do with law, these sources. Like, for example, if the case is about Silesian minorities, what happened in Silesia and how it actually worked, like what if the case is about transgender people, some developments in understanding of what transgender, how transgender phenomenon actually developed. Nothing to do with law, very useful for understanding the facts. The court is not expert in this area. The court uses the sources. Now, the second area is to understand the law of the contracting party. Sometimes it is crucial, and in many articles of the convention, you have this lawful something. So this lawful means lawful from the perspective of the national law. So for the European Court of Human Rights, it's extremely important to understand how national law works. That's why national judges are always members of the composition of the chamber and grand chamber in the court. But also the court sometimes refers to national legal scholarship that explains what exactly a particular rule or provision means in the national legal order. The court, technically, of course, we have a national judge, but the court as a whole is not an expert in this area. The court is not an expert. The court quotes something that was written by scholarship on the national level. And the third, and also quite significant area of citations is international law. Usually, law of war, especially in cases where the court deals with issues of jurisdiction, occupation, use of force, etc., etc. Although there are sometimes there are judges who are experts in international law on the bench. But again, the court is not as a uniform entity, is not an expert in this particular area. The court uses these references. What is interesting, the court in my majority almost never, please prove me wrong, but never uses references to academic scholarship looking specifically at the interpretation of the European Convention of Human Rights. What we found, we thought that the court just doesn't want to give an impression that somebody knows better than the court. So there are the masters of the rules, and therefore there is no point in citing some lousy professor from some lousy university that would tell them how to solve a particular issue. This is not true in relation to dissenting opinions. They do cite often quite broadly scholars which are working on the European Convention of Human Rights, but even then, an interesting trend can be identified. They often like to self-cite themselves. So again, it proves the same point that I was just making before. Or they like to cite their colleagues, again, pointing in the same direction, or members of the registry, lawyers of the registry, like your colleagues, Rassim from the European Court of Human Rights, which also points in the same direction. So that is our finding based on purely looking at what type of sources are used by the majority specifically. Nika, would you like to add anything to that?
I think you're absolutely right, Konstantin. I think there is I think it is quite striking when you look at the selection of the citations, the selection of the sources, so to speak. And I think in the case of the majority, I think you're onto something very specifically because this is what we discuss in general in the article, but it is true. I mean, the most striking instances where the court cited something, it was essentially not in its area of expertise properly so called. So, for example, looking at the law of occupation, obviously the court will have to make determinations that hinge on determining as an incidental question whether there is an occupation or not. But this is not what the court will adjudicate by way of principal claims, right? The court will look at whether or not there is a violation or whether there is not a violation. Before doing that, it will look at whether or not the particular events occurred within the jurisdiction of the court itself, of the convention itself, and so on. So it will be a question of scope of application. It will be a question of existence or lack of existence of a violation. But beyond that, the court is not essentially tasked or equipped to adjudicate a matter relating to the existence of a state of military occupation, and therefore they will normally rely on external sources in order to do so. That's just the prudent thing to do, and of course, in doing so, and this is perhaps the most, this perhaps connects well with the question of audiences. In doing so, they will try to do so carefully enough and in a manner that is considerate enough, and therefore they will rely on expert consensus on this particular topic. So I think this is absolutely correct, and I don't think it is particularly surprising in a way, but it is striking because every time the court cites something in the majority, it tends to be one of these situations. And of course, I mean, this is not to say that scholarship that is specifically on the convention is not important. We are aware, of course, that there are some doctrinal pieces on the convention itself, which have been cited a lot by dissenting judges or minority opinions. And perhaps most importantly, I think we all know from anecdotal evidence that every judge of the European Court of Human Rights has in their chambers one or two copies of the different commentaries to the convention. It would be striking if they did not look at them during the deliberations. But of course, this makes sense. I mean, it stands to reason that they would choose not to quote from them in order to again appear as they are the masters of the instrument.
If I can jump in with a little joke, I think that one of the interesting in investigative project would be to go to the library of the European Court of Human Rights and ask what books and articles judges actually borrow in this library. I'm not sure that we will be able to do this research for privacy purposes, but it would be very, very interesting to see with what literature actually the judges engage. Thank you.
Thank you for that. Let's also discuss in brief the citations of so-called non-academic sources. The sources of literature, the citations of philosophers. You point out that there are the cases when the judges in minority do that with some so-called rhetorical introduction, rhetorical purpose or rhetorical aim. What is your attitude to such a practice, and do you think it is positive, negative, or any other conclusions about that? Nіколло.
Konstantin, you take this one because you have researched the non-academic sources more.
Yeah, but I wanted to know your opinion about whether you like it or not. So you put me on the spot. Yeah.
No. I mean, I don't mind it. I think it is. So just to clarify, I think this falls very squarely in the realm of okay, we're trying to contribute. It's both a question of persuasion and a question of audiences, in my view. And essentially, both questions are one in the same if you look at them from a specific lens. But I think it is very clear that sometimes these particular sources are selected for the impact that they will have, because of course they sound to an extent out of place, so they trigger our own uncanny valley feeling because we are not really expecting a citation to Shakespeare or to other historical sources in a judgment of the European Court of Human Rights. But at the same time, they tend to be imbued with moral judgment about something. So again, I believe that they are quite specific in attempting to subvert perhaps the ordinary understanding of what a judgment or dissenting opinion could be, and they are capable of drawing the audience attention and perhaps I suppose raising spirits in certain ways, which are conducive to making the argument.
Thanks, Nico. Sorry for putting you on the spot. I think that I will be a classical lawyer when I say that my attitudes to rhetorical pieces would be it depends. It depends on what is the aim, and whether they are basically appropriate in the circumstances. And sometimes I 100% agree with Nіколло. It's an issue of audience. The judges can show, look, I'm the same as you. You know, like we read the same books, we relate to the same cultural paradigm. We live in the same kind of world. We have some cultural references that we all can understand, and that's actually that may work towards persuasiveness of the opinion. But sometimes you really read these rhetorical points and you don't understand what they exactly doing there, and that is more problematic, but also might reflect the narrow-mindedness of the authors of this piece, because like maybe there is some layer of complexity of meaning that we just couldn't actually sort it out. But I wanted to, reflect this question back to you, Rasim. What do you think about using non-academic sources for persuasive purposes?
Thank you for the question, Konstantina. I agree with you that it depends, but mostly it helps me to understand the arguments, and sometimes it may be more persuasive than the logic arguments. When you see the very relevant citation from the well-known philosophers, it really helps you to connect those immortal works with your particular situation. So it seems to me that it helps really, but it is also the matter of the size and the amount of such citation. There should not be a lot of them, because it will. It is not a literary work at the end of the day. So we can use that this instrument with extreme cautious way. Let us also discuss a situation within the national judiciaries. From your point of view, is it necessary, is it positive to develop such national system as the Ukrainian one, and to encourage the national lawyers, judges, prosecutors to use the doctrine in their court disputes? Should they have such a habit, which should be brought maybe from the universities? What is your point of view on this question?
If Nika, you let me kick off on this one. Again, this is a complex. Thank you very much for asking. This is a complex question. Generally, I think that it's good that judges read scholarship, right? But scholarship can also be bad scholarship, like useless scholarship, badly written, like not giving you anything. So I don't think that scholarship is a medium that can be used for so many different purposes and mean so many different things. It's like saying, is it good to use internet? Well, of course it is, but also of course it isn't. You know, depending on what exactly you do. If you steal money from using internet, well, probably like it's not the best use of the internet. But if you are like, I don't know, researching or what we do now, recording podcasts, is probably more positive than something else. So I would say what I don't like is when there are certain clear rules that every judge has to have at least 3 citations per judgment to well-known it looks like, Rassim, we are coming from the same area. It looks like, I don't know, in Soviet time, you have to refer to Karl Marx and Friedrich Engels and Vladimir Lenin 25 times. And this made absolutely no bloody sense whatsoever. So, like, I don't like that. If there is a complex case, if there is a lively academic discussion on the national level, to demonstrate the position of the court, I think it's a fantastic thing to do, to cite. If it is citation for the sake of citation, I think we are wasting everyone's time. Thank you.
And I have one minor point as well, and I think it is important to acknowledge what scholarship can do and what it cannot do. To cite, I always remember that one of my first reads as a student of international law in this country was reading Vaughan Law's short book on international law, where essentially he concludes that in some cases international law can be very useful, but in some other cases it's best to call a priest or a plumber, because very simply that's not what it can do, right? And I think it is important to acknowledge these kind of things, in particular in relation to scholarship. And I would make a very small point in relation to an article that has been published recently on the Harvard Journal of International Law, which is called "Let's Us All Agree to Die a Little: The Unfulfilled Promise of Third World Approaches to International Law," which I found extremely interesting and refreshing, because I make no mistake, I am an empirical legal scholar, if anything, somebody who is very doctrinal and quite positivist in many ways. But it's striking at times how distant the scholarship, which is very theoretical, may appear to somebody who is a practitioner. And the introduction of this article recounted the story where essentially a person who had been a practitioner in the UN system for a while and who was from a developing country looked at the scholarship written by Third World Approaches to International Law scholars and said, "I agree with this wholeheartedly, but I cannot use this." Right? This, for me as a practitioner, is completely useless because it doesn't provide any real solutions. It doesn't engage with the problem. It essentially provides a plea for changing things. And absolutely, we should, but that doesn't help me. And so, to my mind, this kind of raises two different questions. The first is whether or not scholarship should even attempt to resolve problems, right? Because the argument can be scholarship that raises an issue which, we don't really know how to address, but it's clear injustice. It has absolutely, it is entitled to be scholarship. It is entitled to be called scholarship, and a judge who wants to cite it should be able to do so if they find that useful. But at the same time, it is difficult to draw the conclusion that, judges, or for that matter, even students or anybody else, should engage with this kind of scholarship, lock, stock, and barrel, just as a way to do things which might not be intuitively something that follows and obtains from the reading of the scholarship. So sometimes these are very useful things, but sometimes they just might not be. And maybe time is best spent by looking at other things, in particular for a judge whose time is limited because, the European Court of Human Rights receives 8 million cases per day. That's of course that's an exaggeration, but it's only 7 million. But the point is that there might be other things that a judge is tasked with doing, which might be more important than scholarship. So we acknowledge that, we understand that our interest in this topic is such that we would like judges to engage more, but we are also mindful of the fact that, days have 24 hours, even for judges of the European Court of Human Rights.
Thanks for that. Unfortunately, we are almost running out of the time, so I've got one short last question. Do you have plans to proceed with the relevant research, and maybe you are proceeding with ongoing research regarding the citation or the use of scholarship? Should we wait for the later articles on this topic?
Oh, we are going to have a franchise, like the whole series, like, part 1, part 2, like this Star Wars, like then there will be prequel to that and everything else. No, of course it's an area that interests us a lot. It's the area that is definitely worth looking. As I said, there is plenty of unanswered questions that are still interesting to answer. But having said that, it requires a lot of effort and a lot of manpower to deal with these citations, to fish them from the case law, and especially if it start dealing with chamber judgment, the numbers quadruple, so to speak. So this is a difficult issue unless Nіколло, gets some sort of magic AI tool that can fish these citations easier. It took us, I think we started talking about this project, in practical terms, not just hypothetically, in late 2019 or something like that. So it took us like good, or even maybe before that. I need to go back. So it took us like good 5-6 years to actually collect all the citations, analyze, discuss, finish, read all the materials and stuff like that. So if you're expecting another one like in 3 months, I have to disappoint. Nico.
No, I agree entirely. This has been a lot of work, and yes, I mean, it is possible that in principle we're going to look at this more. Personally, I'm looking at some additional questions outside of the European Court of Human Rights context. I have been looking, for example, at the reliance of scholars on scholarship by the International Law Commission, because I find that particularly interesting. But most of this, a lot of this work is also kind of an attempt to optimize pipelines so that we can extract these things a little more easily. Because again, the problem really is extracting this kind of data, which is really unstructured and not very orderly, so to speak, is an enormous amount of work. And to be perfectly honest, if we start talking about chamber and committee judgments, you get to 25,000 very quickly, and that creates a bit of an issue, because of course you might be looking for material in a fairly large set of data, which can take a toll on your mental health, really. So we'll look into that in a bit, and but we can't make any promises for the moment.
Thank you for that. Again, thank you for finding time to discuss these questions, because they are really important. Of course, this conversation will give us an ability for the better understanding of the problems which you raised in your research, to understand what stays above your particular wording in that article. And I'm sure that some of the researchers will be encouraged maybe to continue work which you began to do, and hopefully in some 3 or 4 months or years we can see the development of such studies, because the role of the doctrine is the issue which is really very important if we want to achieve the connection between the academics and the real practice, and not only on the matters of the international private or public law, but also in the matters of the development of national judiciaries, because there we can see the very rational and reasonable arguments which could be used to find the common sense resolvement of a particular case. So thank you very much. Maybe you have some closing remarks, or you want to add something to finish our conversation, please.
Yeah,
the floor is yours.
Yeah, thank you very much. Huge we hugely appreciate that you took time to read our paper, and it's clear from your insightful question that you did engage with our points, and we're happy that JustTalk was interested in hosting this discussion, this podcast, and we are really grateful to the organizers. And also we're grateful to them because they took quite a massive task of translating what we wrote in English to Ukrainian and making it more accessible to some, I would guess, quite significant proportion of Ukrainian legal scholars and practitioners for whom English is not the most convenient language to read. So thank you to the organizers and JustTalk. They did a great job on that. I don't know, Nico, if you wanna.
I just want to join your remarks and I'm going to add a concurrence, so to speak. So thank you very much again. It's been a great pleasure and fantastic to engage on our scholarship on with you. So thank you very much again.